Abusia, mati issue be what? Yes, say NPP to lead protest. NPP to lead protest on August 6, 2026 with other political parties and CSOs to defend the country's democracy. Debut, more democracy, more than more to my info for Mama, yeah, say Ghana democracy, no, and before say, as a democracy in the tongue, and to more defend it to defend. Democracy in Ghana, and just more defending democracy, no, na now. Burkina Faso democracy, Anna. Togo for every Anna. Gabon, Munye serious. Adia, Nina go by mammy, said Dina Tamakulo and Semian. So, on Montese, appeals court, I quit mamma and I discharge him. Anti democracy, no, era into more bomb by the only protest. Che, what would also your judgment be kind on? Sticker NPP sticker, honorable sticker, on it the finance officer, no master call. I testify in favor of said Dinatamako said. Contract now on sticker bar, master call. Omo renegotiate contract no and I can for that authorize payment. What I said na just onye payment hey where dey bobo judgment amoso go the same mo prosecution go for dame ono na lead at force ne japa issue and position say only like reasonable proof be also can dey go for Japan at force the same reason and the more question dame why that's what they say the market na untia erebre me kanfo lawyer edugitama kuro ama say we dey wo be pension wa tie o kenkan tie bi na wa so ubofo a wo go protest no dwene ho say ade aye ka se yakoyi democracy dwane anase mum ne dwane fi democracy no I was a video.
If you observed and follow the trial properly, yes. And I'm sure we'll have the benefit. Or maybe I can proceed because in the evaluation of the record, let me put this on record.
Right.
The second accused convict, Daniel Aziz,
yes.
As we speak, is on bail.
A CEO.
No, the director of operations,
yes,
who
yes,
was tried
chief operations officer. Yes, he's the CEO. Daniel Aziz.
Yes, he's on bail, pending appeal. So you have a situation where, and guess who granted him the bail? Oh. The Supreme Court of Ghana. For the Supreme Court to look at an appeal on a criminal matter and proceed to grant the person bail, what it tells you is that the Supreme Court is satisfied that there is a high probability that the appeal will succeed.
Right.
As we speak, that second accused convict is on bail, pending the determination of his appeal. So when from all this talk, when from the impression being created that there's something extraordinary, your Attorney General prosecuted a bad case. He did a shoddy work. Unfortunately, the trial judge, from the judgment of the Court of Appeal, appeared to fill in the gap. I am always minded by the reason, in fact, the validatory judgment of His Lordship Justice Pegan in the case of Osei Kwejo II. He said, look, when a charge is defective, it is incurably bad. You cannot cure the defect with evidence. You can't.
Right.
And so in this trial, basically what happened was that the trial just sought to fill in the gap for the defective charge sheets.
Right.
And that is why the Court of Appeal, in its reasoning, came to the conclusion that you cannot invite an individual to respond to a charge that the particularities are extremely lacking. In any case, the Supreme Court has already decided, in the case of the Republic versus Ernest Thompson, that where the charge is defective, it will be set aside. And that is why in the Ernest Thompson case, the charges were set aside until the Attorney General went back and refiled new ones. That is good law. It's still in our laws.
Right.
What was the basis of the prosecution? First of all, that whole thing was a charade. I'll tell you. There's an auditing firm called Bafwewa and Associates. That is the auditing firm that the NPP used for 8 solid years to hound former appointees of President Mahama. I feel sad. I've watched commentaries by people associated with the NDC on this matter, and I said, look, you have no idea what this young woman had gone through. That is hounding at the highest level. What did Bafwewa and Associate do? When the NPP came to power, Nanaya Osafo at the office of the president Anes brought this man, Professor Duajiman. And basically what the Professor Duajiman committee did was to select former John Mahama appointees and do audit of all of them. So Morrison and Associates were giving Ghana gas. Bafwewa and Associate, Maslock and others, deliberate. So it was on the basis of these audits that they now went to Yoko to proceed with the investigation against SEDI. Now read the records. I decided to bring a copy of the judgment here today.
Okay.
And for those who say optics, so keep an innocent person in custody, I wish you well. Look, if you look at the proceedings, and I want us to go to pages, do you have a copy?
Yes, I do.
Pages 74.
74.
Page 74.
Yes,
are you there?
we're here.
This is PW7. The Yoko officer under cross-examination. This is what he says. During the investigation, you were furnished with several documents listing several towns under the sensitization program. Is that not so? Answer: that is so. Question: did the investigation by Yoko involve any attempt to speak to any of these persons listed in the several communities on the documentation furnished to Yoko? Answer: the sensitization program was organized by 85,000 participants with a budget of 1.7 million Ghana cedis. As part of the program, we do not have the contact numbers of the so-called beneficiaries of this sensitization program. If we had, at least we might have placed a call to one of them to confirm or deny indeed the program or organized or they were given 20 cedis as TNT. Now listen to the reasoning of the Court of Appeal. It said this admission is significant. It means that Yoko neither confirm nor refute the appellant assertion that the Maslow program took place in fact. It is also striking that the respondent, that the Republic, called no Maslow regional director to give evidence or be tested in cross-examination, but instead it relied on the evidence of PW6 and PW7 based on information given to them by the regional directors. PW7 testifies as follows. You have only concluded that there was no sensitization because you claim that the funds used for the exercise have not been accounted for. Is that not so? Answer: that is not so. Then question: what is the case then? During the course of our investigation, Yoko interviewed 3 regional directors of Maslock, and as part of the audit conducted by Bafwewa and Associates, they also spoke to all the regional directors, and they indicated that there was no sensitization program organized. Also, even though an amount of 1.7 million was approved for the program, there is no evidence to suggest that the monies were used for the intended purpose. Now, question. As we sit here, there is no means of establishing whether or not these regional officers spoke to Yoko or Bafwewa and Associates. Answer. That is not so. What information do you have beyond what you have stated in court? Answer. As part of the audit, this information I have given to the court is part of the audit report. Also, the 3 regional directors who came to Yoko gave statements. I am saying that before this court, only information is based on what you and Bafwewa have said. Answer. That is not so. Question. There is no testimony before this court by any regional officer of Maslock. I'm putting it to you. That is so, my lady. This is the kind of prosecution you conducted.
Mm-hmm. Wow.
And you want this to form the basis.
Serious. That's serious.
To put somebody in prison. Leonard, as defense attorney, would you tolerate this kind of shoddy work? The regional directors were not dead. You didn't even come to court, even with the statement they offered to Yoko, even for whatever it's worth. Because you knew that there's no way you can build a better case. That is how you operated under your 8 years rule. But even more shocking, you proceed to say that.
So the court ruled based on hearsay.
Even more damning ones are coming. Look, wow. If you look at page 81, and I invite you to look at page 81. Listen, this should never happen again. It matters not whether you are NDC or NPP. I also recall your testimony was that it was not relevant because you got to know that it was used for the purpose for which it was withdrawn. Listen to him. Let me even start from page 80.
Okay.
94 paragraph. Interestingly, upon the perusal of the record, I find that prosecution led evidence to collaborate the appellant assertion that she distributed the money to victims. PW1, and you know who PW1
is?
Who's
PW1?
Sticker.
Oh, okay. Who was then the Maslock boss?
Yes. Testified under cross-examination on 24th May 2021 as follows. You testified some days ago that the issues in respect of Dwadifo Adamfo are no more relevant. Was that your testimony? Answer. Yes, my lady. Then he proceeds. I also recall your testimony was that it was not relevant because you got to know that it was used for the purpose for which it was withdrawn. Answer. Yes, my lady. How did you get to know that it was used for the purpose for which it was withdrawn? It was through inquiry. Inquiry by who and to whom? By Bafwewa and Associates. That led us to that conclusion. How did you inquire from them? We inquired from both within and without. Within means after speaking to some officials of Maslock and then some officials of Dwadifo. But I cannot pinpoint which one of them. We came to the conclusion that the matter had been resolved. If it had not been resolved, we would have put forward additional documentation. Is this the testimony of yours captured in the report you tendered? Answer. No, it is not captured in the report.
Interesting.
Now listen. This admission by Sticker strikes at the very foundation of the charge of stealing against the appellant. PW1 Sticker knew that the appellant had distributed the funds to the victim. PW2 confirmed as much to him. Yet, the material fact found no place in the report tendered in evidence. if the funds were applied to their intended purpose, the allegation of dishonest appropriation cannot sensibly be sustained. And this is how we went about the prosecution.
Mr. It follows inexorably that the prosecution failed to prove beyond
reasonable doubt.
Reasonable doubt.
Look at another issue. Bo, they brought the director of finance of Maslock, or the head of finance, PW5. And look at what happened under.
Which page is this now? 90.
Page 85.
Oh, 85. Still 85. Okay. So page 85. All right.
And the charge against Sedi was that she paid herself and her deputy, that's Mustafa.
Yes.
And for that matter, the judge found her guilty and convicted her as one of the counts.
Okay.
Now listen to what happened under cross-examination. You tendered Exhibit AD, AC, AB, which relates to payment of end of leave and ex gratia to A1 and her former deputy. Is that correct? Answer: that is correct. Question: the payment were processed by your office. Is that correct? Answer: very correct. Question: the processing was based on documents relating to the appointment of A1 and her former deputy. Is that correct? Answer: very correct. In processing for this payment, did you notice anything untoward? Answer: no, I did not notice anything untoward. Question: you put your signature under this payment because you did not find anything wrong with this payment. Is that correct? Answer: I authorized those payments because I did not find. This is the prosecution's own witness. Meanwhile, said he was convicted for this. Meanwhile, said he was convicted for this. I am sitting here and I'm wondering, what republic are we organizing? Mob? A senseless mob? To please a mob? Is that what it is?
Right.
But you see, now, and you come. Now, if the prosecution's own witness, PW5, had come to court and testified, and quotes, he said, I authorized those payments. It was not said. Meanwhile, this was enough basis to convict her. And the most shocking part, shocking, and I've seen NPP people put out there in their social media platform that an amount of 61 million Ghana cedis was appropriated by her. Listen to what happened under cross-examination. Again, sticker.
Page.
I'm taking you there. You know, Sika came on board as one of the PW2.
Yes.
Do you know that the payment for the buses were done in 2017 and 2018?
Really?
Yes. SEDI didn't pay one cedi. One cedi.
The inflated price.
One cedi she never paid. It was Mr. Kenoforiata who issued the warrant for the payments. Said he was convicted for it. I mean, look, it's incredible. And if you look at the testimony of Stika under cross-examination, Stika himself admitted that when he took over as chief executive officer of Maslock, okay, he renegotiated the contract. On the basis of that renegotiated contract, payments were made. Meanwhile, said he was convicted for causing financial loss to the state. You know, I know that as a political party like the NPP, at least you want to show that you were serious in government. I mean, that's fine. Curiously, it was under the NPP administration that the entire value for the buses were paid. And Stika, who was the first prosecution witness, when he came before the court, admitted this. So what was the basis for the conviction then? And that is what most of these NPP guys, they don't even know that the payment was authorized by Mr. Kenoforiata with a warrant. So as we speak, Sedi is in a Sawan prison for payments authorized and done by Mr. Kenoforiata. And you say that optics, so keep him in jail. Like the Roman Colosseum. Keep the mob happy. Let more blood be spilled. To the extent that the mob is happy, continue to do that. I have a challenge with that reasoning. I believe that no one should be convicted for an offense when it is demonstrably clear that no such evidence was led. Before I yield, let me respond quickly to something that my attention has just been drawn to. There's a leading member of the NPP called Kofi Ofosu in Cancer.
He used to be the head of the NEIP.
He just posted something on Facebook claiming that there were missing pages in the records. What he didn't know.
Records filed by who? The Attorney General?
No, the records of appeal.
Oh, the records of appeal.
Usually the appeal is records,
yes,
so
yes.
it's in different volumes.
Right.
The Attorney General, the Republic, filed a motion for rectification of the record and required these 3 documents to be included in the records. Lawyers for SEDI opposed the application on grounds that the documents they were requesting for were documents given by the prosecution itself. And so how in God's name do you have documents and still be demanded? Okay,
so this is it.
So this is the
views of a senior lawyer. Says okay, so he's also quoting the view of a senior lawyer. He says the procedure for pointing out incomplete record is not to be done through written submission. Written submission is read after data has been fixed for judgment.
So much of ignorance. So much of ignorance. What he didn't know was that a formal application for rectification was put before the Court of Appeal. And if you look, let me see. This is the affidavit in support. We herefore depose to this affidavit dated at the Attorney General's office 6th day of May 2026. And look at the request. Now the Court of Appeal. This is the ruling of the Court of Appeal. By court ruling. This is an application or notice by the Republic applicant for rectification of the appeals record. It has been opposed by the appellant. We have carefully considered all the processes filed. Detailed oral submissions of both counsel for the parties herein from the record of appeal. It is a fact admitted by both counsel that there are 3 documents are in volume 1 of the record. And as disclosed, The main issue is whether or not the record of appeal contains exhibits tendered as Exhibit AM, AM1, AM by courts. We therefore rule in the circumstance we have no legal option than to grant the application in the interest of justice and speedy trial. The application is hereby granted. We order that on condition that the registrar of the Court of Appeal, which is seized with the case now, has 3 of the exhibits and the rectification to be done at the Court of Appeal. So these things were done. So you put out misleading, false stories out there just to please, with respect, a mob looking for blood.
Okay.
It cannot be the blood of an innocent person.